Hi everyone, good morning, and welcome to our presentation and virtual roundtable discussion on reconstructing the post-pandemic workplace. My name is Jennifer Singh Jenkins, and I'm a labor and employment lawyer at McInnes Cooper's Halifax office. I'm joined today by my colleague, Michael Murphy, who is a labor and employment partner at McInnes Cooper's Halifax office as well. So today we're going to be discussing the easing of COVID-19 restrictions across Atlantic Canada and challenges employers face reconstructing their workplace in light of all of the changing and rapidly changing health mandates. In particular, we're going to be covering broadly three topics. We'll discuss whether current workplace restrictions continue to be reasonable, how to deal with employees who resist changing restrictions or return to the office, and tips and learnings about remote work arrangements to apply in the future. So as many of you know, in the past month across Atlantic Canada, provincial governments have very quickly changed COVID-19 mandated health restrictions, and there's been a comprehensive easing of restrictions so far in New Brunswick, Newfoundland and Nova Scotia, and soon to be PEI. And if the past 2 years have really taught us anything, it's that circumstances change quickly, and you as employers have to be prepared to adapt to this continuous change. And again, this widespread easing of COVID restrictions is just yet another situation that you're going to have to adapt to. So just to briefly summarize the easing of restrictions. So in New Brunswick, Newfoundland, and Nova Scotia, most restrictions regarding masking, physical distancing, and gathering limits have been dropped for organizations and businesses and for discretionary activities. There's still some exceptions in vulnerable sectors like hospitals or long-term care facilities, but for the most part, we've seen this widespread dropping of government-mandated restrictions, and PEI is slated to follow suit in early April 7th, and they're going to be dropping a lot of those same restrictions. So as provincial governments lift COVID-19 restrictions, the question arises as to what measures are going to be considered reasonable in the workplace in light of the lifted restrictions, and what do you as employers do next? So we have a polling question here for you. In light of easing public health COVID restrictions, are you considering changes to your existing COVID policies? And we'll give you some time to answer. Okay, so it looks like the majority of you, 67%, are considering changes to your existing COVID policies. 14% still not sure yet, and 19% not considering changes yet to your existing COVID policies.
That's great. So that's interesting to see those numbers. And, you know, I think it makes sense to be looking at those policies and considering possible changes. We are still in the early days of restrictions being lifted, and of course they haven't yet been lifted in PEI, but it's good to take a measured approach and see how things play out. We know from experience with the pandemic that it can take twists and turns. So we don't want to sort of get too far ahead of ourselves. And so the question though, in looking at those policies, you know, with mandatory restrictions being lifted, it doesn't mean that we can necessarily just go back to the way things were, because as much as we would like to flick a switch and say the pandemic's over, I don't think we're quite there yet. And on top of that, of course, there are still laws that apply in terms of providing a safe workplace for employees. The thing about the restrictions was that they sort of gave cover or clear guidance about what employers could expect from employees and what kind of rules they could put in place, and served as a benchmark. And so now that they're gone, it is a little more up to individual choice and employer choice as to what they think is reasonable and what is reasonably required. And so when you look at that, the primary driver, and I sort of think about this as, you know, what's old is new again, because these conversations that I've been having over the last few weeks sort of remind me of the early days of the pandemic, when things had just started to happen and employers were wondering what to do and what was expected of them. And so like then, the answer is, you know, you look to your obligations under the Occupational Health and Safety Act, which is to, you know, put reasonable measures in place to protect health and safety of employees. And so then, well, what's reasonable, right? So that really depends on a few different factors. Number one would be the type of workplace that you have. So and the type of work that that people do. And so if you're an employer where people are working with vulnerable populations, then stricter measures may be required. Or if you're an employer that is operating in the retail sector or in a space where customers and members of the public may be interacting with employees, then that would be something to take into consideration in terms of meeting these obligations to provide a safe workplace. And so there are these different factors and how you assess the reasonableness of different policies that you'd want to put in place. So when we think about, you know, the different restrictions that have existed, so mandatory vaccination was always a pretty hot button issue. That as a measure may seem less necessary in you know, certain workplaces versus others. And it is a sort of one of the more strict requirements for an employee, particularly those who require mandatory vaccination or, you know, you get put off work. So that would be one that would probably have to be revisited, because of course the reasonableness of that could be based upon the government mandates themselves and say we're simply following the law. You know, but other things like social distancing and masking, which aren't that you know, interfering with the employees' personal choices and so on, those would be more reasonable in most workplaces to maintain some level of masking or social distancing requirements. So if we can flip to the next slide. And so what we would suggest is, when you're looking at your policies, if you haven't already, and considering making some adjustments, you know, you'd want to look and think about some of these issues. And again, it's very context specific and it depends on the workplace, but some of these factors here may be helpful for you in deciding the extent to which you want to keep these certain restrictions in place. So likelihood of contact with people with communicable disease, interaction between employees and the public, interaction between employees and vulnerable people, and so on. And so some other possible measures, and again, I keep thinking back to the early days of the pandemic, and the key thing to keep in mind here as well is that although the restrictions have been lifted, governments continue to provide guidance. So in Nova Scotia, public health guidance remains, you know, you should wear a mask and you should continue to socially distance yourself. So that guidance is still applicable, and it can still be relied upon by employers to say we're still following best practices in putting some of these things in place. And so some of these would be familiar and they may already be in your policy, but you know, maintaining frequent cleaning schedule. If you're not going to have mandatory masking, there should be some optional preventative measures otherwise put in place. Continuing to support workers who have COVID symptoms, supporting physical distancing, and so on. So again, I won't read out all of these different things. You can read them yourself, but I think the key here is that, and there may be some additional precautions on top of these things for certain workplaces as well. But the two key points is that if you do decide to change your existing COVID-19 policies, it's important to communicate those changes to your employees and to ensure that everybody is educated and made aware that these changes are being put in place. And the second key piece, as I'm sure you're all aware, but COVID still remains to some extent a moving target, and so staying fresh on these things as well, and you know, keeping up with the latest news and updates in order to ensure that you have some flexibility in your policy. And so, as I would always say, in any policy that you introduce, there should be something in there to the effect that it can be changed at the employer's discretion based on operational needs and so on, so that you maintain that flexibility and that employees can expect the you know, changes to be made when necessary.
Thanks, Mike. And so with the changes in government mandated COVID-19 restrictions, and the fact that most employers who had a physical workplace to begin with are recalling workers back to the workplace, issues are going to come up, or have, you know, probably already come up with some employees who may be unwilling to return to in-person work for a variety of reasons. But the ones that'll probably come up the most are someone who doesn't want to return to work because they're uncomfortable with restrictions that have been modified in the workplace, and they don't feel safe. A second common reason that will come up is someone who has a medical condition or maybe immunocompromised, and they disagree with some of the modifications to restrictions that have been made in the workplace, and feel that could put them at, you know, potential risk of further exposure and adverse consequences. And the third scenario that will come up frequently is someone who has become accustomed to remote work and who wants to continue to work remotely in the future. So let's explore these scenarios a little bit further. First, starting with medical condition. So what if an employer reduces workplace COVID-19 protocols, for example, no longer mandate masking in the workplace, and an employee says they have a medical condition that makes workplace exposure to COVID-19 a significant health risk? What should an employer do in that situation? So this question potentially raises human rights considerations. So when an employee raises that they have a medical condition that prohibits them from fully participating in the workplace, it can trigger an employer's duty to accommodate that employee, so long as the employee can show that they have a protected characteristic under the Human Rights Act or the relevant human rights legislation in your province. And in these situations, the protected characteristics that's going to come up most frequently is going to be physical disability with these kinds of requests. And once an employer is aware of an employee coming to them with a health concern as a barrier to full participation in the workplace, again, they have to look into that further and go into that accommodation process. And really, that accommodation process is going to rely very heavily on medical documentation from the employee's treating physician. So in that regard, what has to be established is whether the employee has a medical condition that requires accommodation. And just a note on that, employers aren't entitled to know the employee-specific diagnosis, but really just whether they have a medical condition generally that interferes with their ability to fully participate or places functional limitations on their ability to participate in the workplace. How the employee's medical limitations affect their job. So with this, you're going to be looking at the significance of the risk of exposure and the potential for adverse outcomes. And you're also going to be looking at the specific context of the workplace and the chances of that exposure or risk of exposure coming to be. And number three, if the employee has a medical condition and there's functional limitations associated with their condition, exploring what accommodations may be suitable in the circumstances. And that's, again, going to be a very individualized and contextual approach based on the employee's individual situation. But accommodations are going to include many of the things that you've already put in place over the course of the pandemic, including potential remote work arrangements, perhaps modifying schedule. There's a variety of accommodations that could potentially be explored if that request is made out.
And
sorry, go ahead, Mike.
No, and I was just going to jump in and say, I think because and I've heard it already, it's like some employees expressing fear with restrictions being lifted, and maybe there's no longer a mandatory vaccination policy. And so some employees saying, well, now I'm concerned because all those people who were maybe working from home or were otherwise off work and weren't vaccinated, or new employees potentially, now I'm going to be in a workplace with people who aren't vaccinated, and we no longer have a masking requirement, and whatever that may look like. So that's where that concern is coming from. And some of it may also be mental disability claims as well. Those who may claim sort of anxiety or stress as a result of having to return to the workplace. And but I think it's the same question and the same process that applies is as the employer, you have to explore that with the employee and see if an accommodation is necessary.
Yeah, and I think the other thing for people to keep in mind is that if an employee requests like a specific accommodation or their ideal accommodation, they're not necessarily automatically entitled to that. They're only entitled to what would be considered a reasonable accommodation, so not their most ideal solution. And they also have to cooperate with you throughout that accommodation exploration process. Okay, so let's move on to the next scenario here, which has to do with safety concerns. What if an employer reduces workplace COVID-19 restrictions and an employee refuses to perform or attend work because they don't believe it's safe?
Yeah, so this again, and I keep saying this, but it keeps bringing me back 2 years ago, because this was also a frequent issue of that initial sort of concern, employees not wanting to go out in public at all, not wanting to get on the bus in order to get to work and so on, and wanting to refuse work. So again, it's the same old rule that applies under any occupational health and safety, refusal. So employees have the right to refuse unsafe work, but their refusal has to be based upon a reasonable belief that the working conditions are unsafe. So it can't just be kind of an irrational fear or I don't like the new rules, so I'm not coming to work. There has to be some reasonable basis to have a concern about it. But in response to that, if an employee raises a refusal to work, employers do have an obligation to investigate and attempt to address those concerns. And so it can't just be a blanket, too bad for you, you need to come to work. There has to be at least some assessment based upon the employee's specific grounds for refusing. And so then if the employer ultimately determines that the refusal is unreasonable, so for example, if the policy is adjusted to remove some restrictions but retain others, and in keeping with sort of public health guidance, then I think most employers would be reasonably well assured that that a refusal to work would be unreasonable in those circumstances, absent some special circumstances for that employee. Which again, I would tend to think that maybe there would be a medical reason, and then that sort of brings in the human rights piece that Jen was just speaking to. But if it's unreasonable, then the employer can insist that the employee return to work. And if they don't return to work, then there could be consequences for the employee. If the refusal is determined to be reasonable, then the employer would have to find some solution in order to address the basis for their refusal. So again, let's say it's somebody who's immunocompromised and they have a public-facing role, and they say, now that we're not requiring people who enter the business to wear a mask, I'm very concerned for my own health. And so in that case, then as the employer, you may say, okay, well, let's find some reasonable accommodation for you to allow you to continue to perform your job while balancing that with the changes to our policy. And then the next question we have is, what if an employer recalls employees, but they ask to continue to work remotely? And so there could be two different scenarios there, or several different scenarios, but the two that we have there are an employee who's been working remotely for 2 years because the employer reduced the number of employees in the physical workplace, or an employee who's been working in a hybrid arrangement for 2 years, splitting their time between the workplace and remote work.
Yeah, so I think this is a situation that could potentially come up for a lot of people, especially where employees have become accustomed to greater flexibility with their work location. So ultimately, if there's no medical condition or no basis for refusing to attend the physical place due to safety, really the only limitation on an employer's right to insist on workers coming back to the workplace is contractual. So unless there's a express or implied contractual term of employment granting an employee the right to work remotely, then an employer can insist on their return to work. And so what do I mean by an express or implied right? So an express right would be something that is physically stated in the employee's employment contract. So if someone has an employment contract that says, Jennifer, you're entitled to work remotely, then that would be an express contractual term. An implied contractual term is a little more it's a little different. So it's not something that's actually put in writing necessarily. It's really something that comes out of the conduct of the parties and the circumstances. So for example, someone who used pre-pandemic worked from a physical office location, physical office closed during the pandemic, and then they worked remotely for 2 years. That circumstance could potentially become an implied term of employment that the employee has a remote work arrangement. However, on that note, I think that if an employer insisted that an employee with that arrangement come back to the physical workspace, I think that the employee would have a hard time arguing that that term has fundamentally altered their employment, like the work location of their employment, because of the extraordinary circumstances of the pandemic. I don't think, and it remains to be seen because we don't have case law on this, but I don't think that a court or adjudicator would look too favorably upon an employee who's trying to argue that they have a right to work remotely now because they've done so for 2 years when it's not in their employment contract. When what the employer was really doing was taking steps to ensure the safety of their workplace in light of a global pandemic. So I think that'll be a potential interesting issue that comes out of this. So if there's no expressed or implied contractual term, then an employee who refuses to come into the physical workspace could be justifiably met with progressive discipline for their refusal to return to the physical workspace.
Well, and I think that, yeah, that's the interesting thing about that is, some employers may have moved towards the remote work approach and hired people, who are living in Toronto or BC or, all across the country. And now that things are changing, for those employers who may wish to now require those people to come back to work, that would be, you'd be up against it, I would say, in terms of requiring those folks. And then just Jen, on your point, one thing to be wary of is the communications that may have happened on the implied contractual term. It would be important to look back on any representations that were made to an employee who says, my job is now a remote work arrangement, because courts do tend to favor employees where, if they could say they had a reasonable understanding or expectation that this was now the type of job that they had. So that would be something to look out for as well, in terms of, if you put somebody off and it was pretty clear this is a temporary measure and we're doing it out of public health issues, then the risk is low. But if representations were made in any way that could give rise to an expectation of some permanence to that, then it would be a little riskier.
So now we're just going to get into some best practices for recalling employees to work in person in light of changing COVID restrictions. And so to minimize employee dissatisfaction with return to work and possible termination liabilities and recalling employees to in-person work, there are a number of things that employers may want to consider in a return to work plan. So number one would be the pace at which employees will be returned to work. Might want to consider returning employees in segments that reflect operational needs or employee preferences. Number two would be flexibility, which I think is a big thing to come out of this pandemic that most employees have enjoyed, and any flexibility that you can offer or are prepared to offer and allow employees to work remotely, whether it's part-time or on an occasional basis if it's not something that you can implement full-time. Things like infection control measures, which Mike already kind of touched on, that reflect any remaining public health guidelines that may be in place in a specific context and characteristics of your individual workplace. It's also important to communicate your plan well in advance of recall. If you're going to be implementing remote work or having remote work as a complement to your physical workspace, structuring and having in place some kind of remote work policy, and also taking the time to thoughtfully respond to refusals and maintaining that overall flexibility with this kind of constantly changing and evolving pandemic.
So that brings us to sort of remote work arrangements generally, because this is it does seem to be part of the new normal, that even though I'm sure there are many employers that are looking forward to having people back in the office and going back to the way things were, others have fully adapted to the new model, and a couple reasons for that. One being for retention purposes. We know that it is a bit of an employee market out there in lots of industries due to labor shortages, and so allowing for this kind of flexibility is something that employers see as a benefit for their workforce, and it's something that employees have come to expect. The second is productivity, and this may not be true in all industries, but some employers were certainly surprised to see that productivity didn't go down when people started working out of their bedrooms and kitchen tables, and in some industries, in fact, people even became more productive, and so it's just another kind of positive outcome that's causing many employers to want to continue with these arrangements. And of course, the third basis for it is the larger pool of possible recruits and candidates as well. So we're no longer hemmed in by our local markets, and can expand the scope of a job search, beyond the city in which the business operates. So lots of reasons for heading in that direction. And so we have another poll to throw out there. Do you have a plan? Do you have or plan on hiring remote workers? Liked one of those, and I'll give you a minute or so to click the button. Okay. Oh, wow, interesting. Okay, so only 21% saying yes, 19% unsure, but 60% no, no plan to hire remote workers on a go forward. Okay, so for those who are considering it, there are a couple issues to keep in mind. The first would be on the contract side. If you're hiring somebody as a remote worker, you want to make sure that their employment contract reflects that work arrangement. And so some of the things that you would want to have addressed there would include expectations around availability and hours of work, to ensure that employees know, when they're supposed to be working. And it's not just, it's obviously to ensure productivity, but the other piece of it is you'd want to make sure that employees understood how overtime worked when they were working from home as well. And you'd want to have something clear on that any overtime would have to be subject to prior approval from management and must be recorded and so on. Otherwise, you could find yourself with a, owing much more in wages than maybe would have been initially intended. You'd want to ensure that the employees understand what their duties are. And I would say in any employment contract, you'd want to address the employment duties, but It is very important in the remote work environment where there's maybe a little less direct, interaction on a daily basis, in-person interaction. The third key piece would be addressing security, because if somebody's going to be working from home, they may be dealing with confidential information, and you'd want to be sure that that confidential information wasn't just sitting out on their kitchen table or in some other public space in their house that could be easily viewed. So you'd want to have rules in place to address, how they can use that information. And again, that I would say in any employment contract, you would usually want a clause on confidentiality, but all the more important for those who are working remotely and potentially dealing with confidential information outside of the brick and mortar work location. In addition, you would want to have some policies in place to address working from home, because your contract can't deal with all the ins and outs and procedures that you'd necessarily want to have in place for dealing with that. So that's another aspect to consider. And under that, broad category of policy, a key consideration would be occupational health and safety, because you've got people who would be still, in the course of their employment while working from home. And so if they were to be injured, and Jen will speak on a case in a moment, but there could be a potential workers' compensation claim. And of course, if their workspace wasn't safe, there could be occupational health and safety complaints as well, in issues that could arise there. Maybe not a complaint from the employee, but certainly OHS may, if there's an injury, OHS may have conduct an investigation and do their own review. And ultimately, as the employer, you would bear the responsibility to make sure that they had a safe workplace. And so that doesn't necessarily mean, sending in your own Josh inspector or anything like that, but it could be at a minimum requiring a self-inspection for employees, and ensuring that they have, a checklist in place and clear guidelines and expectations about what their home workstation is going to look like. And so that as part of a due diligence defense, as the employer, you could say, well, we did everything that we reasonably could be expected to do to ensure that their remote workplace was safe and in accordance with applicable law.
Yeah, so as Mike said, occupational health and safety is an important consideration with remote work arrangements. And there was this really interesting case that came out in December of last year that made quite a few headlines in the media. So the name of the case is Air Canada versus Gentile-Patti, and it's a Quebec based case. And in that case, what happened was an employee was an Air Canada worker who worked from home. And as she was going on her lunch break, she was going from her office upstairs down to her kitchen, and she fell on the stairs while on the way to her lunch break and injured herself. Air Canada argued that the fall did not occur during work because she was on her lunch break. And it also argued that it had no control over the worker's activities when she was not at her physical workstation or at her computer. So the issue that the tribunal in Quebec was tasked with determining was whether the worker's fall on the stairs of her residence while going on her lunch break was in fact an event that occurred during work, and whether she had a compensable injury. And ultimately, what the tribunal found was that the employee was entitled to compensation under workers' compensation for her injury. And in so finding, they indicated that the context in which the injury occurs must be considered. And in particular, they stated that the tribunal must seek the purpose of the activity carried out by the worker at the time of the occurrence of the event. If the purpose of the activity carried out does not fall within the framework of the activities, expectations, concerns, or objectives of the employer, it will become part of the personal sphere of the worker and can't be considered as occurring during work. So they also went on to find that where there were certain factors in the incident that made it an unforeseen and sudden event occurring in the course of the worker's work, specifically that in this worker's job, she was required to A, work from home, and B, she was on a precise schedule for her breaks, so she knew what time during the working day that she would be taking her breaks from work. There was also a short lapse of time between when she stopped working at her computer and the actual occurrence of the accident. So ultimately, they found that the accident was connected with her work. And another thing they discussed was this concept of the personal sphere versus the working sphere. So while they acknowledged that Air Canada's absence of control over the workers' home, they did find that there was other jurisprudence on this issue that included many other situations in which the criteria for compensation was deemed to have been met, where an incident took place in a location where the employer was unable to exercise any control. So for example, in a hotel, conference, or in a parking lot managed by a third party. So ultimately, they found that the injury was one that was suffered at work, and she was entitled to compensation in this case. And again, I think it's interesting because the case kind of, to some extent, raises a blurring of lines between work life and home life, and an employer's lack of control in some respects over an employee's at-home workspace. So I think the decision could result in more employers considering what measures they can take to ensure that employees have a safe workspace at home, whether it's requiring employees to conduct like a home workplace safety audit, or potentially some form of increased monitoring.
Yeah, absolutely. And I think it just goes to that point, right? Like some accidents just happen. I mean, she slipped down her stairs, so maybe there's nothing the employer could have done there, but it does call to mind, or sort of going back to the idea of having a policy and rules in place about somebody's home work environment, because if you do have some clear guidelines and rules, then if an employee gets injured, but they're acting outside of those rules and expectations, then that could be a basis to say, well, this wasn't really an injury in the course of employment because they weren't following the rules and what our expectation was. So all the more important to sort of try to define that for employees. So with remote employees, the other big consideration is of course what jurisdiction applies. So it's great to be able to have, reach out and hire somebody who's in BC if you're, or rather the other way around, I guess, from this slide, if the company is based in BC and wants to hire somebody in Nova Scotia, or vice versa. But the law that applies, the employment laws that apply, will be based upon the employee's residence. And so even if the business is based in Nova Scotia and hiring somebody in Ontario, even if 95% of employees are in Nova Scotia and only a few are in Ontario or in other provinces, the law that will apply will be that person's home jurisdiction. And so when I say employment laws, I mean occupational health and safety, workers' compensation, employment standards, as well as human rights legislation. And so some best practices to keep in mind if you're hiring new employees, you want to make sure that the contract complies with the laws of the province where the employee resides. And so this is something that that we've seen, and it's where you've got your employment contract that you're used to using, and you hire somebody new and they're in a different province and they sign the contract, but it talks about Nova Scotia law and it refers to the Labor Standards Code and other applicable legislation here in this province. If that person's in New Brunswick or Newfoundland or PEI or anywhere else, then that contract won't be valid. Because their own home jurisdiction, the laws in their jurisdiction will apply. So you'd want to be sure that it's catered to each specific employee's situation. You'd want to ensure that location is clearly marked out in the agreement and that the employee knows that they are restricted from being able to relocate without approval. And so that's a key factor, because if that's not there, the employee could say, well, I'm a remote worker, I can go wherever I want. I'm going to go live in Mexico and then I'm going to change home provinces or whatever they want to do, but that could render aspects of the contract void unless you've got a clear clause in there saying that they can't do that, because then you could always go back and say that they were in breach of their contract by leaving their original location. And of course, it's good to check in and ensure employees are in fact working in their original jurisdiction. Because even if they don't ask for approval, but otherwise it becomes a known thing that they've moved. And as an employer, if you don't follow up on that and take some action on that, then you could be seen to have condoned it. So you'd want to be following up and ensure that you're aware of where your employees are situated. And for existing employees, if they're going to be moving to a new jurisdiction, if operations are going to be relocated, then in those cases you may want to look at putting a potential amendment to the contract. So if somebody's in Nova Scotia but they want to continue working for the company, but they're moving to New Brunswick, then that would be a good basis to put a new employment contract in place for them to address that change and make that a condition of allowing for that relocation. Now, it could be at their request or it could be at the employer's request. One way or the other, you'd want to make sure that you documented that.
Okay, and so given the nature of remote work, again, as we've kind of mentioned earlier, the lines between being at work and not being at work can become a bit blurry when someone is working from their home. So in this regard, we're going to discuss just briefly this kind of fairly new policy that has been introduced in Ontario. So in a recent legislative change in Ontario, they have become the first province in Canada to follow the lead of many European nations, legislating that employers have a right to disconnect from work policy. So Ontario actually amended their employment standards legislation to require that any employers with more than 25 employees have a physical written policy on disconnecting from work. And what they define disconnecting from work to mean is not engaging in work-related communications such as emails, calls, messages, and just generally to be free from performing work. And this, interestingly, this includes all employees, such as managers as well. But with the amendments that have been made to the employment standards legislation, they really don't have much teeth to them. The only substantive requirement at this time is that employers simply have a policy in place addressing disconnecting from work. There's no regulations or guidelines in the amendments about what an employer actually needs to have in their right to disconnect policy. So there's not really a true right to disconnect from your work yet, I would say. The only substantive requirement is to actually have some kind of policy in place. But that being said, I think the goal behind the legislation, at least at this point, until there's more information included about, what actually needs to be in those policies. I think the goal is to raise this as a consideration for employers, for this to be top of mind, that there has been this blurring of work and personal life throughout the pandemic, and just generally with electronic communications and the ease of which we can quickly respond to each other with electronic communications, and to start thinking about whether some kinds of guidelines are needed in the workplace, and to make sure that employees are not continuously monitoring their emails. So I think the fact that this was introduced in Ontario is a sign of things to come in the future, potentially in other provinces. And with these kind of right to disconnect policies, I think there is the potential to improve work-life balance for some employees, and there is a benefit to having a clear delineation of what are working hours and what are non-working hours. I know that one German company who has implemented a right to disconnect policy actually shuts down their email servers at 7 p.m. every night, so you couldn't send an email at that time if you wanted to. So they have very clear delineation of when their working versus non-working hours are. But at the same time, as Mike and I have mentioned earlier, flexibility has become increasingly popular throughout this pandemic. So these kinds of right to disconnect policies could potentially hinder work-life balance for some employees who, for example, may go to a dentist appointment at 3 o'clock, and rather than using sick leave or vacation time to do that, they might just put in an extra hour at the end of the day to make up for that lost time. So these kinds of policies could potentially, take away that flexibility that people have enjoyed over the last little while with their work arrangements. And there's also potentially some operational issues for businesses where global markets are operating 24/7.
So we now have a little bit of time to address some questions. Just before we do, you can see on the slide here a little plug for MC Legal Labs, which is a customizable training workshops led by members of our labor employment team to help support continuous learning for HR and other staff in your organization. So please do reach out if you have any questions about that, or if you're interested in having MC Legal Lab in your workplace. We did get some questions in advance that were provided, so I'll just address some of those. So somebody asked the question about terminated employees, and what happens to them now that restrictions have been lifted. And I think it's a reference to somebody who was terminated, let's say, because they refused to abide by a vaccination policy, or didn't provide proof of vaccination, or otherwise didn't follow policy. So, and I think the answer is it ultimately depends on what that termination looked like. If it was a true termination, i.e. you're not following policy, we're going to let you go, then their employment is over and there are no remaining obligations to them. And as far as the liability for the termination, it would be based upon the law and guidance that existed at the time that occurred. So it's not like somebody could say, look, the restrictions got lifted, 3 months after I was let go, clearly their policy wasn't fair. I think any court would look at it and say, well, they were, at the time that they were let go, we were in a very different situation. And so that would be the answer there. Now, of course, if somebody was not so much terminated, but laid off or put off work with an understanding that they could come back, then if your policy changes and you no longer require mandatory vaccination, then it would be incumbent, obviously depending on what your policy says, but to contact that employee and to allow them to return to the workplace, because that rule is now no longer in place.
Yeah, and I think, and we have a question here popping up. So what if an employee moved during COVID to another province or location further from the office? Because of the amount of time that has passed, do we need to accommodate? And I think, so with that question, I think again, we need to consider, whether there was an express or implied term in the employment relationship that permitted the employee to work remotely. So if there's nothing in the employment contract that allowed the employee to actually change work locations, we'd also look at the circumstances surrounding the employee changing work locations. Was it something that was discussed in advance with the employer, agreed to verbally or over email? We look at all those circumstances to determine whether or not it may be considered an implied term of the contract. And that would kind of help guide us as to whether or not, what sort of level of potential flexibility or accommodation needs to take place with that kind of request.
Yep, and we have another question. What if an employee states they have a family member at higher risk and therefore they can't bring it home, so ask for accommodations? Again, that was something that we also saw in the early days of the pandemic, and I think it's under human rights legislation, there is an obligation not to discriminate against people because of their association with somebody with a protected characteristic, and so that may fall under that category, where the person could say, I need this accommodation because of my spouse or because of my children and these health concerns that they have. So I think it's relevant, but it starts to get more remote. And so then I guess it would still be the same sort of process where you can ask for more information from the employee and ensure that whatever accommodations you provide are appropriate, and not just, to go back to Jen's point, it's not, the employee has to be reasonable as well, and they can't expect a perfect accommodation or just make a demand and say, I want to continue working from home because of this issue and I won't consider anything else. They don't have that ability. It's really up to the employer to review and decide, well, what is the actual risk and what are we doing in the workplace, and is this concern legitimate, and what more can we do to help address this individual's concerns.
Okay, and so we have another question here. Please comment on the strength of mandatory vaccination policies in today's work environment.
Yeah, so that's a good question, and I think it'll be our last one for the day. So that's, I would say that it just, to go back to that idea of every workplace in its own context and what would be required, as far as what makes it, when you're doing an assessment of whether it's reasonable to still require it. So if it's a long-term care home or a healthcare setting, or potentially working with other vulnerable populations, then still requiring vaccination could very well be a reasonable approach to take. Whereas if it's an office environment and there are other less restrictive, because when you look at, well, what made mandatory vaccination reasonable in the first place, and you kind of picture having to explain it to a judge, it would be look at the circumstances that we were in. We were in an unprecedented global pandemic. Government had passed all these, mandates and rules, and we were doing what everybody else was doing, and that would be a strong measure of reasonableness. Whereas, if we are sort of passing that point and moving into sort of the next phase of just living with COVID, we haven't really required in the past people to get vaccinated for the flu. And if ultimately COVID is moving into that stage, then what's the reasonable justification for the special treatment of COVID at this point? So again, I know that's not, I think it is just an answer of it depends on the workplace and the environment that you're in. That's, it has to be sort of assessed by on that basis. I think the other point that we haven't really mentioned is, these restrictions having just been lifted. I think it's reasonable for employers to take a bit of a wait and see approach as well, and to do things in phases. So I don't think it necessarily has to be we're going to completely revert back to pre-pandemic approach. We can take, this is stage 1 and stage 2, and then see how things play out. Maybe a new variant comes along, and we'll be happy to have not simply thrown out the entire COVID protocol that you'd put in place. So again, I would just say, take a measured approach on these things. So that's it for us. I don't think there's any more questions coming in. So thank you so much to everyone for joining us.